43.
May I please?
Item number 42 and 43.
Yes. This is a challenge month diploma from the NIOS under the MHRD direction. The Lordship is probably aware of all of that. Now, the reliance on a Supreme Court. Can your Lordship hear me?
Yeah.
Yeah. The reliance on a Supreme Court judgment and on the basis of which this non-sitting has happened. Now, my submissions are. I have three submissions which are independent and alternate. The first is that it's a complete misreading of the Supreme Court judgment to say that the 18 months course has been delayed. Because the Supreme Court judgment, and I will take a Lordship's way, very clearly says that this is a one-time window of opportunity for in-service teachers for which the second proviso to Section 23 subsection 2 was brought about, and to give them the minimum qualification in terms of Section 23. So once I am qualified, the question therefore my non-student does not arise. And the court also, Supreme Court also said that these will not apply to fresh applications. So basically, all those who were in service in 2015-17, whenever the amendment came into force, and if they have acquired the 18-month diploma, would be at par with the rest, and therefore acquire qualification under Section 23. So that's one. Two, Malaks, the judgment also in terms of equivalence. Now, this is the second submission. It says that there's a finding of the court, and correctly so in the case of, because in the case of Uttarakhand, they have Section 23(1) saying that 18-month course is also applicable. And I would submit, Malaks, that NCT already having issued a regulation under the NCT Act saying that the 18-month course is a valid one. All that it is required, Malaks, that an mandamus can be issued to them because it is already a stated stand that they can issue, if the need arises, to issue a circular superseding that 2 years and saying that 18 months is also applicable. And thirdly,
your projected case.
Yes. And third, projected in the reading, but on a careful reading of the judgment.
Mr. Ajoyka, can I just, some queries, if I can just ask. The scheme of things that was there in that 18 months course was limited to the in-service teachers to make them at par with the qualifications under the RTE Act. Then the regulations of NCT, which was holding the field 10, 12, 14, were never corrected or were never amended. It continued to have that 2-year prescription. I have failed to find out, that's what I want from you. I failed to find out a notification from or a decision of the NCT saying that these two qualifications are the same. Now, this equivalence came to be declared by the Patna, right? Followed by the Tripura High Court. So, beyond these two judgments, is there an independent decision of the NCT that these two qualifications are the same, equivalent?
Which Malaks are issued because in terms of a section, in fact, 40.
Okay, you can take me through 42. That will be relevant.
The primary teacher possessing DED, IODL qualification from Nios. It will be relevant to the reply of NCT dated 6th of September 2019, which reads thus. I am directed to refer to a letter dated 29th of August 2019 on the subject of law to say that the representation regarding requirement of primary teachers qualified with DED, ODL from NIOS has been examined. The primary notifications are those dated 23rd of August 2019, 2010 and 29th of July 2011. Determination of minimum qualifications, etc. The following points are inferred from the above notifications, copies and I will be, as per notice, for fresh appointments today, the appointment of teachers for classes 1 to 8 is a 2-year diploma in education. It further clarifies that NCT recognition order dated 22nd of September was only for those untrained in-service teachers in government schools, the inherited schools, who were appointed on or before 10th of August 2017. It further clarifies that for fresh appointment of teachers for primary and upper primary level, NCT notifications dated 23rd August 2010 and 29th July 2011 wherein it provides a minimum of 2 years diploma as a minimum qualification for appointment of teacher. At the cost of repetition, we clarify that the notifications dated 23rd of August 2010 and 29th of July 2011 years regular diploma, particularly so when there was no material placed on record, even remotely hold that such a notification was recommended by the expert body. I should have also 23. Qualifications for appointment and terms and conditions of service of teachers. any person possessing such minimum qualifications laid down by an independent authority authorized with part is concerned, if case your lordship is of the view that equivalence is not there, and the Supreme Court has the Nios has also been provided by the Supreme Court in paragraph 61. NCT has issued recognition, has issued regulations. It is their stated stand. So it is now in requirement of the statutory duty under section 23(1) to members can be issued on the basis of the judgment that you issue a circular specifying equivalence, because you have already said that's the minimum qualification. Three minutes. The Assam rule, which is in page 89 minutes. Assam rule, which is at page 89, because your lordship does not have the prohibition of Uttarakhand. Assam rules adopts 23rd of August, and what is more important, your lordship will just have it's a page 89.
I've got it. There are two rules.
Please, the minimum qualifications for a person to be eligible for appointment as a teacher in elementary school shall be as notified by the National Council of Teacher Education number with the so dated 23rd of August, which is that 2 years. Now, the second part is very important. The provisions of all rules, notifications, orders of the government prescribing qualifications for teacher, which are repugnant to the stipulations laid down, laid down by the National Council of Teacher Education, stands superseded. So today, the 22nd of September 2017, which are the recognition order, is an NCT stipulation. So how can the Assam...
Mr. Hazarika, I'm not sure whether you have been brought to your notice. We have another rule, specifically for the service wherein the advertisement has been issued. We have a manual, this manual. It's called the Assam Elementary Education Provincialization Rules 1977.
We cannot violate the Supreme Court's order.
Now, Mr. Hazarika wants this court to issue a mandamus to the NCT authorities for incorporation of that in that rules, in that regulations. What do you have to submit on that?
On that, the Supreme Court has also said that till now NCT has not done anything.
So when the Supreme Court has not done
Anything, how can this honorable court
address me on that? Should this court come in?
Absolutely no. This will be clear violation and in conflict of the Supreme Court judgment. Had there been any scope in the Supreme Court judgment, Lordship, that scope would have been there. But there is no doubt or any confusion regarding the language used by the Honorable Supreme Court, especially paragraph 51. The earlier two rounds,
46 will clear.
46, the Tripura were not correct in law. What remains, Lordship, thereafter? And paragraph
The matter is finally considered after hearing and
I'm in entire agreement. No, but I may say, and in all respect, because firstly, the rule, what my learned friend was referring to because the Supreme Court at paragraph 53 has said that it did not, that the High Court of Uttarakhand erred because there was no challenge to the rule position over there also. So, today, my submission would be therefore, as far as
that, Mr. Subject to correction, is only an approach with regard to one of the contentions raised. The Supreme Court gave its verdict in paragraph 46-47. Yes, I'm again reiterating this thing you just cleared to me.
No, but
as I have read, NCT never said these two to be equal. It was for the first time that the Patna High Court said both are equal to it. The Supreme Court saying that is bad law.
Therefore, my submission was because today, because eventually it is the ultimate and the penultimate paragraphs of the Supreme. The Supreme Court says in paragraph 56 and 57 that you have acquired the minimum qualification in terms of section 23. That if I have acquired the minimum qualifications of terms of
Okay, let's test that. Let's test that argument. If that was the intention of the Supreme Court, why did it interfere with the judgment of the Uttarakhand High Court and did not pass an order to the NCT to incorporate that?
Because the Supreme Court, in paragraph 43, made a distinction between, I think, paragraph 43, made a distinction that it is not for fresh appointment it cannot happen.
This is fresh appointment, Mr. Hazarika. You are not appointee under the government or in a school appointed in terms of norms of the government. You may be anywhere. You may be a private institution, individual. You may be a contractual work employee with the or an ad hoc employee with the government. But you don't have a root in the government service.
So may I just let's look at it the other way around. What is the implication of this judgment? The implication of this judgment that this 18 months course is a valid minimum qualification in terms of section 3.
Yes.
Now, therefore, if I have a valid minimum qualification in terms of section 23, does it mean what is the implication? The implication that I can not only continue to be employed in my present position, I can also be employed elsewhere.
That's the catch. That's the catch.
This is the catch.
That's the catch. If you come to the decision of the Supreme Court, here it has categorically said
Fresh appointment. Fresh appointment
will not appoint to fresh appointees.
No,
Mr. I just try to factor in this also in your argument. This 18 months was only to get the teachers across the country who did not have the minimum qualification with regard to RT achieve that. This was a student-centric approach of the government. It was nothing to do with the teachers. It was a student-centric approach so that the students are not deprived of a proper education from a trained person. Now, keeping the view in the mind, as far as I have understood, the Supreme Court had proceeded.
So
What do you have to say?
So my first submission.
I am examining this only with the view whether I should permit you to appear in those elections.
I am grateful. As far as permitting me to appear in this whole process, as I said, let me address this query of your lordships. Today, if I have, that's what falls from your lordship is that this being a student-centric thing may have been the perspective, but in terms of the statute, in terms of section 23, I have the minimum qualification. Having acquired a fresh appointment with me, because why it also is, and I think that is because it says that minimum qualification section 23 I have also provided to me.
So you mean to say that the Supreme Court judgment has not considered that effect of 23 provision? So it's per inquiry, I'll have to declare it per inquiry.
No, it is not. Because the Supreme Court has not said that they are not. Did not say that.
This direction regime is binding on me.
No, what it meant in terms of fresh appointment was someone who was not in service. Today in service means someone can be in service in a private school.
No, the advertisement says any person in government service in an LT school cannot apply. You got it. We will examine. Don't worry. We will examine.
It is permit me to also participate in the process because after all.
I'll examine that. Because for your information, the government is extending the date till 12th.
Is not.
So till 12th. Right?
Or it is general.
Generally, for all. So these orders, I'll pass it tomorrow morning. Let me consider. I'll pass it tomorrow morning.
But we have serious objections because we do not want to.
I have understood your objections.
My objection is for any kind of interim order. Lordship may be pleased to issue notice. We have looked out. Paragraph 15 very clearly takes care of section 23, section 29, and as well as all the notifications. And also, whatever has Lordship has regarding the 1977 rules.
293.
We cannot violate that. We cannot violate that.
Because I had a doubt first.
Till date,
As Mr. Hazarika is trying to project, as to build up a case, that there was a rule with the Uttarakhand government. That rule was violated, and the Supreme Court has made some observation in that line also. I was in doubt as to I did not know that this provision was added. While consulting the book, I got we are in a better the state. I think has put itself with NCT.
yes.
With NCT.
Paragraph 53, last line.
Okay.
The High Court, in our view, in respect of the other cases, the High Court, in our view, could not have issued such a mandamus contrary to such service rules.
Yeah, that is Mr. Hazarika is also trying to take. But But that was one of the limp of the arguments.
And paragraph 51 very clearly says for the ratifications.
Exact nerve of this judgment is paragraph 45, 46 and 47.
Yes, Lord.
Because other than Patna,
And the contemporaneous efforts in paragraph 51.
we'll try. Let's see how best we can help you.
And 1921 we did it because till that time the Uttarakhand judgment was not there. We are with Hazarika, but today we cannot.
No, that's the Supreme Court
liner was I am supporting him, but today I cannot.
You cannot.
My learned friend only has to pursue the judgment at the applicable in terms of the manner in which it is given. But in paragraph 56 and 57, that's enough. It is quite fine.
Mr. Hazarika, I am facing
The irony is that when my Lord Justice Nair was on the other side, we always saw the Patna High Court and Tripura High Court against him.
This was the argument maybe I could have done. let me consider. Tomorrow morning, 10:30.
I am grateful.
Highly obliged.
ਸੁਪਰੀਮ ਕੋਰਟ ਨੂੰ ਸਮਝ ਹੀ ਨਹੀਂ ਆਈ ਨਾ ਉਹਨੇ